And and yes, you will get copies of the slides. Somebody just asked that. Hi, Lori. So, okay. So I want to introduce Charla. We're so pleased to have her here today. Charla Stevens practiced law in New Hampshire and Massachusetts for more than 37 years. She spent the last 21 years at McLean Middleton, which is a regional law firm in New Hampshire with more than 100 lawyers, where she chaired the employment law practice group and also represented schools and the healthcare practices. Since retiring from McLean at the end of 2021, Charla has established a consulting practice where she continues to offer services to businesses, which include workplace training, independent investigations, strategic human resource consulting, and mediation and conflict resolution. During her years of practice, she was recognized as a top lawyer in employment law by Chambers and Partners, Best Lawyers, and Super Lawyers, among others. Charla is currently the chair of the Granite United Way Board of Directors, trustee of Solution Health, a commissioner of the New Hampshire Lawyers Assistance Program, and also serves on the American Bar Association section of Litigation's Task Force on Mental Health and Wellness. We are so pleased to have her here today to talk about a much requested topic, return to work agreements. So Charla, I'm going to turn it over to you.
Thank you, Karen, and thank you everybody for joining us. I appreciate that you had topics that you asked for, and that's very helpful, I think, to Karen and to everybody else who's trying to plan for continuing education for this great group of people. And I commend all of you for your commitment to mental health, well-being, and keeping individuals who are struggling with various issues working and productive. Mental health and well-being, as you can tell from some of what Karen just read about me, is a major issue and focus for me, from having represented mental health practitioners to dealing with the issue in the legal profession, where there are some profound issues that we as a profession need to address and are hopefully continuing to address. And return to work is a big one, because a lot has been said around employees' rights, employers' rights with respect to leaves of absence, terminations, discipline for certain behaviors. But the ultimate goal is to keep individuals who may be using substances inappropriately productive and working. And so that is our goal with having conversations like this, and certainly with having organizations such as Recovery Friendly Workplace. So I'm gonna kick in. As Karen said, please put your questions in the chat. I have left a lot of time intentionally for there to be some conversation and dialogue with so many participants. It's probably easiest to do this via chat. So just getting started. Just a review of what the purposes of the training are. We're going to do a quick review of leaves of absence and determine how they and discuss how they can be a tool in supporting the recovery of your employees. We'll do a little bit of a review again around communication with employees around treatment and leave. Where this really sort of kicks in with the meat is determining when somebody is suitable and ready to return to work, whether they need some accommodations to work successfully, addressing and discussing expectations with employees when they come back, and then obviously return to work agreements, the written agreement. Why have it? What should it contain? So a quick review of leaves of absence, only to list the categories and not really go into details, because this was all in a prior training. And if you don't have those slides, I am sure they are available to you. So leaves of absence can happen for a number of different reasons. Under the ADA, the Americans with Disabilities Act, where an individual, because of substance use disorders, can be deemed a disabled person who has the rights under the Americans with Disabilities Act, which include reasonable accommodations. And reasonable accommodations can sometimes be leaves of absence in order to obtain treatment or take time to do what is needed to enhance one's ability to enter recovery. Family and Medical Leave Act is a federal law which applies to larger employers, 50 or more employees, but also schools and some municipalities by definition. That's a 12-week unpaid leave of absence to address a serious health condition. Many states have Family and Medical Leave Acts, which provide for payment for time off. Massachusetts has a paid Family and Medical Leave Act. New Hampshire has one, which I am sure many of you, given that you are representing state agencies, participate in. And then leaves of absence can be provided as a company benefit, even though the company is not legally required to provide leaves of absence absent one of the laws, such as the ADA requiring that. There are many companies which offer leaves of absence for medical reasons, for personal reasons, and so that would be whatever is consistent with your company policy. So if you did the last training regarding, a culture which supports mental health, wellness, and substance use recovery, you will probably remember this slide, and I put it in here again because I think it's a theme. What do employees need from their leaders during times of crisis? And that was something that I was mentioning in the context of, a work-related crisis or something like the pandemic. Now I'm talking about it in conjunction with a personal crisis, meaning the need to take some time off or the need to get some mental health support, counseling, treatment, or other support from an employer. And the same four principles apply. Employees are looking for a mutually trusting relationship. They're looking for compassion and understanding from their employer when they're going through a difficult time. They're looking for stability, knowing that their job will be there in the future when they return, and then looking for hope for a positive outcome. And employers can certainly provide all of that depending upon how they handle a situation with an employee who may be struggling. So when someone is going to go out on a leave of absence, leave the workplace for a period of time to get treatment or, to do something associated with their recovery. And we're talking about recovery here in the context of this presentation. But the same principles apply if the employee were going to take a leave of absence for any medical or mental health reason. They're going to complete a request for leave of absence form, which is going to set out the purpose of the leave, the need for the leave. It's going to be filled out in part by the employee and in part by the employee's medical provider. The employer is not entitled to know the expected duration of that leave if it's known. And there are times when the medical provider can't say what the duration of the leave is expected to be, but there can be a periodic review, and the physician or a mental health provider would provide that information in the form. We'll also state whether or not the employer is entitled to receive periodic updates. And certainly if you are in a situation where the medical provider cannot give you an estimated date of return, you would be entitled to those periodic updates so that you can maybe find out how things are going and learn whether or not an expected return date has been established. So that form is going to be provided, assuming it gives you the information that you need. A leave of absence would then be approved, and the employee would go off and take care of whatever it is that they need to take care of. Once the employee has completed their course of treatment, you would request and are entitled to receive a certification that the employee is fit to return to work. A fit for duty certification is sometimes what we call it. It would provide the expected return date. The medical provider, mental health provider, treatment provider, whoever it would be, would certify that that employee is fit for duty. And in order for the medical provider to give you that certification, they would need to know what the employee's job duties are. So you would make sure that they had a copy of the job description and an understanding of what the employee does on a daily basis. When you're dealing with a physical disability, that's a little bit more concrete, where you can say, you know, the employee has to lift X number of pounds, the employee is on their feet so many hours a day, the employee drives. You know, when you're dealing with mental health issues, it is a little bit less concrete, but still important for the medical provider to know, for example, whether it's a highly stressful or fast-paced environment, for the provider to know, you know, whether the employee is on a particular shift, like a third shift, whether the employee works around and with other people. If the employee drives, you know, if the employee has interactions with clients, customers, in very stressful circumstances. These would be important things for the provider to know in order to determine whether or not that individual is ready to return to work in that environment, because it's very specific as to what the job is. The provider will also let you know whether that employee needs some type of accommodation, and that is a reasonable accommodation allowed under the ADA, and is also something generally that the employer is probably going to want to do to help to assure a successful return to work. So an accommodation could be something like modified hours, modified job duties, maybe for a period of time while the employee sort of integrates back into the workplace. Very common for an accommodation that is needed to be time off to attend 12-step meetings, if that is something that the employee is participating in, or to go to group therapy or individual therapy. And sometimes it's not possible to schedule those sessions outside of normal work hours. So maybe the employee is going to need some time off in order to attend those sessions, which are so critical to a successful recovery. So we're going to use Delilah as our example employee. A little bit of a scenario here. Delilah is about to return to work after a 4-month absence for drug and alcohol treatment. She is proud of the progress she has made and is certain that she'll be able to do her job effectively. So she's feeling good about her return. She is, however, worried about how her coworkers will receive her. Most of them don't know why she took leave. She's afraid of being questioned about her health. So this is a very, very common scenario. And one thing I think I probably want to say up front is that individuals who have left work for a period of time in order to participate in a treatment program, they are in the vast minority of individuals who are in the workforce. Obviously, many individuals who are currently in the workforce are using substances, whether it be drugs or alcohol. The percentage of people who actually go to treatment and complete a treatment program, that is a relatively small number in comparison with the number who are actually using substances on a regular basis. So Delilah is already in a distinct category of individuals, and her feelings here are very, very typical of someone who is returning to work. They haven't said why they are leaving, so they're worried and they're concerned about who knows what, who's been talking about her. Are people going to assume that she had some type of medical issue and ask questions about that? You know, what is going to happen when she returns? So she's going to have a lot of trepidation about that. And those first few interactions with coworkers, supervisors, are going to be really important, because she could potentially get derailed very quickly if things go badly when she returns. So what are some of the issues that she's going to be facing? Questions from coworkers, as I mentioned, scrutiny by supervisors. There are probably a limited number of people who actually know why she was out of work. And her direct supervisor is likely one of them, because that person probably had a need to know. So medical information and information about treatment is confidential and should only be provided to those who have a legitimate need to have that information. And the supervisor is probably one of them, because that person is going to need to be involved in the process of reintegrating her into the workplace. But sometimes a supervisor, when an employee returns after some mental health treatment, is going to be particularly on guard as to whether the employee is making a misstep, whether the employee is completing their job. So she may find that she is being scrutinized in a way that maybe she wasn't before or may not be expecting. If she's been gone for 3, 4, 5 months, it's very possible that there have been some significant changes in the workplace she's coming back to. Maybe there's new personnel. Right now, we have a very mobile workforce. People come, people go. So maybe there are new people that she's going to be working with, a new team. Maybe there's new equipment, new clients, new customers. So you don't know what has changed, and she's going to have to deal with that. Rusty job skills, especially if she wasn't performing well before her leave of absence. We can assume that if things had gotten to the point where she needed to take 4 months to be out of the workplace, that she probably wasn't doing very well leading up to the time that she left. So she may not be as on top of her game as one would hope or expect. And there's always going to be the fear of relapse. Those of you who are in the treatment field are aware that, recovery is a process. We've all heard that terminology. And it's the rare occasion when someone, completes a treatment program, never has a misstep, and is successful for the rest of their lives. I mean, things happen. And so when she first returns to work, now she is in an environment, she was probably in a much different environment just prior to her return. And now she's jumping back into the workplace, and, she's going to be stressed. And, lo and behold, stress sometimes causes people to self-medicate. So there's always going to be, from her perspective, at least, some concern that she might relapse.
Charla, I'm just going to interject for a second there. I just want to mention that we have quite a few recovery-friendly workplaces on this call, some who are very much champions in the field. And one of the things, or the advantages of developing a recovery-friendly culture, is that some of these things would not be happening.
Mm-hmm.
There would be things that would be more openly discussed, transparently, say peer-to-peer, and there'd be a lot of support. So I just wanted to mention that as one of the advantages of some of our champions who have developed recovery-friendly workplace cultures very strongly.
Yeah, I think that is fantastic, and that is absolutely out there. I wish there were more. But that is the cause that you're championing, right? And so I'm thinking, when I jump into the next slide, we're going to talk about some of those issues of what does Delilah need. And my guess is that a lot of those champions that you mentioned are already providing this.
Absolutely. Yes.
Number one is the time to reintegrate. To be expected to jump in and be, 100% full force, running a mile a minute, doing whatever that job is really, an unreasonable expectation on the part of an employer. It's going to take some time for Delilah to reintegrate, to reacquaint herself with her former coworkers that she worked with, and with new coworkers, new customers, new clients, whatever it may be. We talk about when people go out on parental leave, their lives have changed dramatically when they become parents. And so we try to give them time to reintegrate into the workplace. This is the same phenomenon. She's going to need some time to get up to speed. She may need some additional training if there are some job duties that she hadn't mastered before, or have gotten rusty. If you have new equipment, new computers, new software, whatever it is in the type of workplace you're in, she may need to get some special training on that. Maybe a period of time to transition to full capacity, not to have as heavy a workload, not to work as many hours in the beginning. Let's give her some time to get up to speed. As Karen mentioned, a mentor or a work friend. somebody who can be a support other than a supervisor, hopefully, somebody who could be a friend, somebody with whom she can be candid, maybe somebody who has gone through the same experience. And, there are workplaces who have people that are very willing to be mentors to folks who are coming back from treatment. And then support from management on the issue of whether or not she chooses to discuss her substance use or not. That is her choice. Other than, as I said before, the few people who have a need to know, no one else has the right to information about where she's been and why. Now, she may choose, and it may be a very good idea if she works in an employment facility with a recovery-friendly culture. It may be great for her to share that. In some workplaces, it might not be a good idea, or she may have some trepidation and not be ready to do that. So whatever her choice is, she needs support from management on that. So what we want to make sure that we do prior to presenting agreements or ultimatums, and I know that Karen and I talked before this session that there are some employers who make the choice to discuss return to work parameters and treatment prior to the employee actually leaving to go on a leave of absence. In the perfect world, that is the best of circumstances, that everything is outlined, everything is clear. And people have an understanding of what will happen. And that's both parties, both the employer and the employee. How long will they be gone? What are they going to need when they return? What are the expectations of the employer when that employee comes back to work? So all of that, if it is discussed up front and agreed to, and there are written documents in place, is terrific. But very often people leave to go into treatment when they are absolutely in crisis. And they're not in a position to have those conversations. It's not the appropriate time. They may not actually have the mental capacity to make agreements, and later, putting on the lawyer hat, there may be an argument that they entered an agreement under duress and just signed on the dotted line so they could get a promise that their job would be held open for them. Legally, if somebody is on FMLA, paid FMLA, ADA leave of absence, there is some protection that they will have their job available to them when they return, and under the ADA is as long as it's for a reasonable period of time, because that leave of absence falls into the category of reasonable accommodation. So you really want to be mindful of what the situation is with the individual when deciding whether or not to have what can be a very difficult conversation up front. But if you can do that and the person has the capacity and ability to enter into an agreement, it's a great time to do it. If not, you want to make sure that you have a pre-return to work meeting with Delilah and include the right people at that meeting. Certainly a representative of human resources, if it's an organization without human resources, whoever is fulfilling that function. And in a small business or department, it may be, the executive director or the owner of the company. So who's the right person who's going to have that conversation? Her supervisor certainly should be involved, and she should have somebody there to support her. So maybe a member of her care team is willing to participate, and Delilah would sign a release to allow that person to be there and to provide information. Maybe a counselor from the EAP, maybe that work friend or mentor, if Delilah has somebody who can be, a support to her and a help to her, because, she's going to be extremely worried about this meeting. She's going to be nervous about it. So we want her to have support there, and we also want to have the right people in the room. We want Delilah to be able to share her experiences and also what her needs are. What is it that she believes that she needs, and then what does her care provider, care manager believe that she needs. Now, you might get that information. You will get that information in the return to work certification form. But if that person is there to have a dialogue, it's so much better and more effective. And what's important to remember is that under the ADA, the employee is entitled to an accommodation, a reasonable accommodation. It may not always be the exact accommodation that they ask for. So some, and we've certainly talked about in the past, and I know you're aware of the concept of the interactive process when somebody is requesting an ADA accommodation. And that is that you have conversation around what the needs are, what you hope to achieve with the accommodation, what the company or the employer can reasonably provide. So I would consider this all to be part of that interactive process. And then to carefully review with her the return to work agreement that you have crafted. And I have been asked to, and I will provide a template return to work agreement. And as I say, every time I provide a template, don't just use the template. Templates can be lovely and helpful in getting you started to draft what it is that you need. But whether you buy them on the internet or get them from a lawyer or track them down, get them from a friend, there may be things in there that do not fit your particular circumstance, or maybe things that you need to add. So it is a guide, not the Bible. So it will give you an idea of what can and should be included, but you want to make sure that it is tailored to the circumstances with which you are dealing. And before I forget, years ago, we used to call, and some people still do call these last chance agreements, a term that I detest and have always detested, because, one of two things happens. It's hard to say that anything is the last chance, because again, like I said, it's a process to maintain recovery. And you don't want that sort of sword hanging over someone's head that this is the last chance. The other thing that I have seen happen many, many times is there's a so-called last chance agreement, and it says it. I mean, that's the title of the agreement. When the person falters in some way, and they get brought back to work. And so guess what? It wasn't really the last chance. So you've said something that is not accurate, and that as an employer really impacts your credibility when you're dealing with the next person. So, just in the same way that I hate the words zero tolerance, I don't like the word last chance, because there's always a gray area in every set of circumstances. So that's why we call them, return to work agreement, or, return to work expectations agreement. But, we'll talk in a minute about what, I believe should be in it. But it's important to carefully review that in advance of her signing it. And then also to give her some time. Take it home, have it reviewed by someone. Make sure that you clearly understand what you are signing, because this is going to be the outline of what happens when she returns, what the expectations are, and how we hope and expect that things will go.
Charla, this might be a good time to ask a question. I had some questions that were shared with us prior to this presentation.
And thank you for those who did that.
Sure. And this relates to ADA rules. So I thought it might be a good time to chat about that, since you've just been referencing that. Sure. But the question is, what are the confidentiality requirements when discussing recovery in the workplace in terms of record keeping?
Okay.
How do return to work contracts interact with ADA rules? Like, can someone with an unpredictable medical issue that interferes with cognition be held to a contract?
Oh, well, okay. That's, we were talking about confidentiality, and then we took a left turn there. So there's two different issues. So the number one issue that you mentioned, which is the confidentiality, and going back to HR 101, right? We have the employee's personnel file, which is confidential. And then we have the employee's medical file, which is, extra secret confidentials. So that the return to work agreement, along with the request for accommodation form, the return to work certification, that would go in the employee's medical file, along with, any kind of medical information you have, if there's been any kind of, pre-employment testing, anything that is of a medical nature is kept separate from the personnel file. And so the people that would have access to that is people who have access to the personnel file. That's a limited number of people, but the people who have access to the medical information is an even more limited group of people. And it's those who have a specific need to know. And more often than not, that is pretty much limited to the file itself, would be limited to HR or whoever is the custodian of the file, if there is an HR. So there's somebody who has responsibility for maintaining those confidential records. If you are in a business or company that has, for example, manufacturing plants will sometimes have industrial nurses on staff, or medical providers on staff, or a medical review officer if you do drug and alcohol testing. Those individuals would have an ability to have access to the file itself, the documents. I would say for the most part, almost no one else. The supervisor may need information about certain aspects. So for example, I would say the supervisor needs to have access to the return to work agreement, because that person is going to be the one who determines whether Delilah is in compliance. So that's important. And then if there are any accommodations, obviously the supervisor needs to know that. If there are scheduling accommodations or accommodations around how you're going to communicate with Delilah, or anything like that, then obviously the supervisor needs to know, because he or she will be the one who makes sure that those accommodations are being provided. No one else really needs to have access to that information. And, any more than anyone needs to know why she was on a leave of absence. All they need to know is that she was on an approved leave of absence. It's up to her to share further information should she choose to do that. Now, the second part of that question is much tougher, and that is whether or not you can hold somebody to an agreement if they were, in some way. And that's why I think I mentioned, like, when they're leaving, before they have gone and gotten treatment, do they have that mental capacity to enter into an agreement? And depending upon their state of mind when they are departing for treatment, they may not, and it may not be possible to hold them to an agreement. They may not have the mental capacity to agree. And so when you are having the person sign an agreement, what I would suggest is that, number one, you give the person time to consider it. You don't stick it in front of them and make them sign it while they're sitting there in the room with everybody staring at them. Maybe they want to have it reviewed by a lawyer. Maybe they want to have it reviewed by their treatment provider, or discuss it with their treatment provider. Also, I think it will enhance the enforceability if that person has the supports in the room with them when you're having the conversation. So if there's something, for example, that somebody doesn't understand or isn't really listening to, that treatment provider or the EAP counselor or their mentor, someone can reinforce, explain, talk it through with them. But I think that the best way that you ensure enforceability is to make sure that the person has the supports, has time to consider it. And if you see any red flags in terms of, not thinking that the individual is understanding what's being asked of them, maybe that might be time to put a pause on it, and then, have them go back and talk to their treatment provider about what they can and should agree to. So I think hopefully that answers the question, but yeah, it's a valid concern, and it is a concern that I would have if you are having those conversations. And asking someone to sign in advance of their going out on a leave of absence. Some people are 100% in a state of mind where they can easily do that and totally understand it, and others may not be, especially if they're needing to detox or that they may not be able to be in any kind of position to make those decisions.
That's perfect. Thank you.
Okay, great. So the return to work agreement, why have one? The number one reason is that it provides protection for both the employee and the employer. So the employee is going to understand what's expected of them, and they will also understand, for example, you would include in it, and we'll talk about the specifics, but those accommodations will be included in it. So it's going to set out the rights and obligations of both parties. Protects the employer because if the employee returns to work and is simply not able to function effectively, you will have options, and we'll discuss what those options might be. It's a great tool for retaining employees. If you have somebody that has worked with you for 2 decades and is a skilled individual and has always been a good employee and has recently been struggling and has had some missteps, why would you not want to support them and get them back to work so that they could be the same effective contributing individual that they were for the last period of time that they've worked with you? So rather than you violated our policy by being drinking on the job, and you can be terminated, and clearly an employer is well within their rights to terminate somebody who has been drinking on the job, but is there a better way to do this? Can we support you in your attempts to recover, assuming you are on board with that and wish to participate in a treatment program, support you and then bring you back. As I said before, setting out the expectations of all parties. What is the employer going to provide to Delilah? What is Delilah going to do in terms of performance or not do in terms of violating policy or, not showing up for work when she's scheduled to do so? And it should do that in a very clear way. The last thing that we like to see in agreements or contracts of any kind is ambiguity. So, we want to make sure that all of those specifics are clearly outlined. So what do we put in the agreement? I usually like to see some kind of a prelude or a setting the scene. And it's sort of the example of like, when you've seen contracts with a lot of legalese in them, the whereas clauses. We're probably not going to want to have quote unquote whereas clauses, but some preliminary information to suggest why we need this agreement. We need this agreement because Delilah is returning to work after a period of 4 months. What are the triggering issues? Was there a policy violation? If there was, you probably want to mention that or say, what is the scenario that caused Delilah to leave the workplace? There was an industrial accident, which was as the result of substance use. There was, a policy violation in that she had been drinking or using drugs and was inappropriate with a coworker. Whatever, we're not a whole lot of detail, but at least some of the specifics of whether or not there was a policy violation. She violated the anti-harassment policy. She violated the no drinking on the job policy, whatever it may have been. So some information there to provide the background information. Because as we know, sometimes with these agreements, maybe the individual who signed the agreement with Delilah is not going to be there in 3 months. And so you have to provide, you have to make sure that there is information there so somebody can interpret it and live with the terms of it. The expectations, and this is certainly the meat of the agreement, the really important piece of it. A requirement that Delilah comply with the treatment recommendations. So we're going to know, hopefully in the meeting with the treatment provider or the case manager, but at a minimum in that return to work agreement, or consultation with the EAP provider or somebody, we're going to know what those recommendations are going to be. So probably it's something like, Delilah will not use any substances. She will attend an outpatient treatment program for X period of time. She will go to counseling once a week, whatever it may be that is being suggested by her treatment provider. The compliance with those recommendations is going to be an expectation of her. Perhaps submitting to random drug or alcohol testing. You are where you may not be able to just require drug testing at the drop of a hat. You can put random drug testing in a return to work agreement. This is a condition of your return to work. Sometimes it would be based on a suspicion. Sometimes it's just periodic. A lot easier, I think, with a drug issue than an alcohol issue, because drugs will stay in the system for, typically many drugs will stay in the system for longer periods of time. So random drug testing, if she's being required by her treatment program and also by her employer to abstain from using any substances, it's perfectly appropriate to put that monitoring in a return to work agreement. We're going to say that she's going to fulfill all her work responsibilities. In other words, she's going to do her job when she's there. She's going to meet attendance and behavior requirements. Absent, obviously, the company or the employer will have policies around sick leave or so, she can take time off if she's sick. She can take vacation time, but, she can't be a no-call, no-show. So you want to put some specificity around there in meeting the employer's attendance requirements, absent having either a policy protected or legally protected reason to be absent from work. Behavior requirements. This is especially true if what triggered her leaving to attend treatment was a policy violation that was a behavior issue at work, either being inappropriate at work or, driving the company vehicle while intoxicated, whatever it may have been. You need to make sure that you have in there some provision that she's going to meet behavior requirements as well. And then an agreement that the employer receive periodic updates from care providers. It doesn't necessarily have to be a lot of detailed information, but information along the lines of she's complying with all treatment recommendations. That alone is, just something that tells you that she is doing what she is supposed to do in order to maintain her recovery in a successful way. The agreement is probably going to have some timelines in it. Is it going to be, it's probably not in perpetuity. So it's a 6-month agreement. It's a year-long agreement. What's a reasonable period of time for that agreement to be in place? And if somebody has been out of work for treatment for 4 months, I would say a minimum of a year is a pretty reasonable period of time for that agreement to be in place. And then what you also want, I think I probably have it in here, but just in case I don't have it in the next slide, what are the accommodations? What is the transition plan? That should be laid out in there as well. And then what are the consequences of a misstep? And I would caution anybody against saying automatic termination, no questions asked. I mean, that's just not something that is useful for an employer to have. I mean, it sounds like it's got a lot of teeth in it, but I don't know that that's going to be particularly effective in making sure that she maintains her recovery, and it certainly boxes you in as an employer. So you can and probably should say in the agreement that there will be consequences, and the consequences might be discipline, suspension, and up to and including termination of employment. In other words, we absolutely have the right to terminate your employment if you are not in compliance with the terms of the agreement, but we don't want the agreement to box us in and say that we absolutely must do that if there is a misstep of any kind. Because you certainly don't want there to be a situation where she all of a sudden has lousy attendance, and so you automatically terminate her. Then number one, there may be another reason for the attendance issues, such as a personal reason at home that has nothing to do with substance use. So you always want to allow yourself some gray area and some wiggle room, while also saying, we certainly do have that right to terminate you. And so that way, if there's some type of egregious behavior, then you do have termination as a resort. Oh, and there it is. Yeah, go ahead.
I was just going to let you know that we're getting close to the noon hour, and I know you're almost done because I've seen the presentation. But I just wanted to mention that because there are some additional questions in chat, plus a couple of others from prior. And just so everyone knows, Charla is willing to stay a few extra minutes to make sure we answer those questions. If we can't get to some, we will make sure she answers them via email as a follow-up.
Yep, happy to do that. And this is actually the last slide, which is around how do we support Delilah. And this is just the ongoing theme of the conversations that we've had before. Prioritize mental health at work for your employees. Make sure you have good policies, have an EAP or some alternative to that, and create a welcoming and responsive company culture. And I know that that's why you are all here, because that is the type of culture you want to provide in your workplaces. So can hit me with some questions, Karen.
Okay. One of the first preliminary questions is one that I'm going to answer. I think it came from the state of Maine, and I do want to welcome all the various states that are here today. I think we have Nevada, Nebraska, Mass, Maine, and Washington, in addition to New Hampshire. So happy you could join us. I believe it came from Maine, and the question was, are there examples of municipal governments in New Hampshire who are recovery-friendly workplaces and who have created these for their workforce? And I did notice, Kevin Kincaid, I'm going to put you on the spot because I know you have those types of agreements. If you want to speak now, that would be great. And if not, I can connect you with this individual after the presentation.
So if you want to send me their information, I can reach out to them and talk with them about it.
That'd be awesome, Kevin. Thank you so much. And
Kevin, checking to make sure I was paying attention, weren't you?
I was checking on you. And then the next question is, do we need to have a consultant permit or license to discuss policy with employers? That's for you, Charla.
Yeah, I'm not 100% sure I understand the question. Is this somebody who is a provider?
I don't have that information.
Okay, yeah, I
if
think
they're on here, they can maybe.
Yeah. And I'll sort of start to answer it, and if they chime in, great. In order for anyone, for a medical provider or someone outside the organization and someone within the organization to communicate regarding the employee's medical issues, and these are medical issues, there do need to be releases. The employee will need to give permission for those conversations to take place. That's a critical part of all of this. Like for the medical provider to complete the form, the request for accommodation form, there need to be releases. So okay. Yes, there would need to be a HIPAA compliant release.
And the next question is, what are some techniques to implement return to work within a short-term work environment, such as a construction project, which may only be 6 months to a year?
Yeah, I think that if the person is, it sounds like you're talking about a situation where somebody is hired for a finite period of time to work on a certain project. And, that's a little tricky because, as we know, a lot of times these things take time. But, I would say that you treat it like you would treat any other situation. You engage in the interactive process around, whether or not there is some accommodation that can be provided, and it's probably a leave of absence. And, who knows what it is. And if the employee is or is not able to return to work within the period of time that the project is expected to last, they can't. And if somebody's hired for short term, they're probably not going to be eligible for things like FMLA under the federal law, but they're still eligible, under the ADA. They're an employee, even if they're temporary. So you go through the process just as you would in any circumstance. If the medical care provider says, they need to be in a treatment program for 6 months, then it's probably not a reasonable accommodation to hold the job open for 6 months. So that's probably not something you would be able to do, but you handle it on a case-by-case basis in the exact same way that you would with a long-term employee.
Makes sense. And then we're getting to a couple of questions in the chat.
Okay.
Nikki asked, I'm curious if there are statistics on how successful people are going back to the job they had before treatment. Are these people more successful making a fresh start in a new position with a new employer? And just to note that Sam, the Recovery Friendly Workplace Program Director, did answer that there is a study that showed on average employer-initiated treatment was more successful than that which was not employer initiated. There are definitely some nuances though, and she provided a link. So in case anyone
great.
in there, and
Thank you, Sam.
And I will just say, I have had a few recovery-friendly workplaces that have had individuals return to the workplace. And anecdotally, I would say it has been successful. And I think, again, it may be on a case-by-case basis. It's probably going to depend on the person and the employer. So, Charla, did you want to add to that, though?
No, I think you've answered it perfectly. And that's great that Sam had that info.
Yes. And then another question in the chat, how does an employer handle drug testing for employees who may use MAT as part of their treatment protocol? Great question.
So that's a whole nother seminar. That's that is absolutely, that is one of the big issues of the day. It really is. I think you work with the care provider in those circumstances to come up with what the protocol might be and what might be appropriate and effective, because we know that MAT is sometimes critically necessary in order to achieve a successful recovery, and that's medication assisted treatment. But when you do the drug testing, you are going to test for certain medications. And my supposition, without being an expert on this topic, is that you will be able to put those parameters into the drug testing protocols so that you may be testing for the drug of choice that individual was using, or whatever the appropriate dosage is to account for what the medication is that's been prescribed, because obviously people may have prescription medications as well, which adds a whole nother complexity to the return to work issues.
And then we have a final comment in the chat. Knowing that there will be random testing actually helps the employee with their recovery. Would you want to comment on that, Charla? Or
I think that yes, it can, because the employee is going to be particularly mindful of that, with the caveat that there are people that are sometimes in such a state or such a condition that they don't have control over that behavior. And we need to be aware of that and mindful of that, but it certainly can act as a deterrent. It's not a it's not a kind of a perfect solution, but it certainly can help in certain circumstances if somebody is kind of voluntarily might participate. Oh, it's just one time, as opposed to someone who truly is in a condition where they don't have control over that behavior.
Thanks, Charla. And that concludes the official portion of our training. However, I do want to open it up to anyone who's still on, and we still have about 73 participants on. If any of you have any questions you wanted to ask verbally, we would welcome those now. And as I mentioned, Charla would be happy to respond to those for a few extra minutes. So please.
Happy to. And I took off the slides so I can see faces And I think somebody's looking at the chat, right? So we can.
That was
Lots of
just,
thank yous. Isn't that nice?
I was just putting my email in there in case anyone does have any questions following
And
this.
You will get the slides, a template agreement, and then a little worksheet checklist that you are welcome to use. And those will come to you.
And also, Charla referenced one of her original presentations that was a precursor to this one. If any of you online here have not seen that, we're happy to provide that for you. So. A lot of thank yous, Charla.
That's nice. And do feel free to reach out. Happy to answer any questions via email or give me a call. I think that the site to my website is on there, and my phone number and email address are on the website as well. So feel free to reach out. Always.
And we so appreciate that, because some of the smaller businesses might really find value in a further conversation with you. They may not have attorneys they consult with and so forth. So that's
right.
So great that you're offering it. And we so appreciate that, Charlotte. Thank you.
That is really an important point, though, that you make. And I usually make that a couple times in these types of presentations. A lot of these issues are complicated, and it's good to work with your employment counsel to kind of sift through it.
Other comments, very informative presentation. Interested to see the example of your return to work agreement. That template is in demand, Charla.
Yeah. Just be careful.
Yeah, right.
It's kind of like, doing your will online, right?
Right. Yeah, so I do see people continuing to drop off. I don't see any other questions. So with that, I would say, Amy, we can conclude the recording, and just want to thank everyone for being here and for your participation and engagement. And we're